specify respondent number 2 is being filed, my lord, that may kindly be called for. Like,
Similar, same item.
Wait, please, my lord. My lord, item number 12, my lord. My lord can close it, my lord. There is no surviving purpose.
Good.
Item number 12, my lord. It's infractor.
Reported the learned counsel on behalf of the petition submits that the writ petition has become infructuous, and according to the writ petition stands closed in time of
All right, my lord.
may I please, lord? Yeah, item number 4, my lord, I filed my affidavit today morning, my lord, that may be called.
May I please, your lordship. First, item number 7 can be listed for adjournment. Action is not listed.
you have taken the permission.
Yes, we have taken. We have communicated to respondent number 7 and they have given the consent.
The request to take the counsel. On number 7, matters stand adjourned to be discussed on 26th of February, 27th of February.
27.
For withdrawal, supplementary item 15 and 16.
My please, your lordship. Both the matters it becomes infectious here, Lord.
Yeah, go. In time order.
Support that is item number 1.
Lordship, this is the matter regarding the financial upgradation.
Last order, Lordship has directed me to get some inspection. So I have procured some inspections. As far as the inspection, Lordship, what has happened is that though AIDC has written to the government and government sought for some information regarding this to take up with the finance department and settle the issue. But it seems like all the information government did not receive. So now what has happened is that they have written another letter to the AIDC and to give all those materials within 3-4 days so that that can be settled. So they have written yesterday only, Lordship. So I have got the, this information yesterday. 3 letters they have written to them that, those letters are already there in the writ petition prior or additional affidavit. So they have written a letter, the second page, Lordship, yesterday.
So, when?
What week, Lord?
Huh?
1 week, Lord.
When are you sending the material?
1 week, Lord.
You have received this document, 12th of February.
Lord.
12th of February, the
No.
documents which have been sought for, have you received?
No, Lord.
When are you sending it?
Lordship, 10 days, Lordship required.
You are sending it when? 10 days we will look into it. But tell me, when are you sending it? This has all happened because of your delay. By 17th?
17, 17, Lordship.
No. By 17th, you send your documents to the finance department, to the industry department.
By 17, Lordship. Today is the Lordship. It's today's 13, Lordship.
You have to send the document.
Okay. Yeah, Lordship. Can it say on 20, Lordship?
16?
As your rules, Lordship. 7.
Mr. Equalita, the learned counsel appearing on behalf of the industry department, submitted that on 12th of February 2024, a communication has been issued to the managing director, the AITC, for submission of certain information within 3 days from the said date of the said letter, so that the matter could be taken up by the industries department at the earliest. The said communication has been placed before this court, and the same is kept on record and marked the letter Y.
Lordship. Lordship.
Mr. J.K. Gustami, the learned counsel appearing on behalf of the AITC, submit that taking into account that the said document have a copy of the said document have also been served upon him by the learned counsel for the industries department. He shall ask the managing director of the AITC to forthwith comply with the directions so issued. And within 3-4 days, the said information would be duly furnished to the industry department, to the director PE Industries and Commerce and PE Department
Yes.
of the government of Assam. Taking into account the above, this court fixes the matter on 5th of March 2024. In the meantime, by 16th
Lordship.
of, you were given 5 days, 3 days out here.
Lordship, 17 is better than 16.
7.
Good.
In the meantime, latest by 17th of February 2024, the managing director AITC is directed to ensure that the information which have been sought for by the communication dated 12/2/2024 by the director of the Industries, Commerce and PE Department is duly furnished, so that the same said aspect thereafter can be placed before the Finance Department if need be.
We had already furnished a copy to Finance Department on the last occasion.
To Mr. B. Gogoi.
Yes, Lord.
Lordship is indicating some time for the Industries Department also to take a decision or something like that. It's not.
In the meantime, both the industries and the Finance Department shall take due steps so that an update can be placed on the next date.
Fifth Lordship is fixed. Fifth Lordship.
This time picking it to give an update what is the score.
Lordship.
Let him submit the document.
Lordship.
Much
All
obliged.
right.
Supplementary item 17, Pathar.
My lord.
May I please, your lordship? Lordship, in this case, lordship, the judgment which has been relied on, lordship, firstly, I'll take your lordship to the judgment which was relied on last time by the respondent. Lordship, the main question is whether my transaction is transfer of right to use goods or service. If I have paid both, I have paid the service tax as well as the VAT. Lordship, Lordship, last time the submission of the respondent advocates was that the judgment in
Let
rate
us
is
not go what the respondent has done. Let us now go on the terms and conditions on which you say that it is a service and not a right to use the goods.
yes, sir, lordship. Lordship, only for my satisfaction, only one
Your
paragraph I will show you.
satisfaction, I will duly take care after first placing before this court which are the terms on the basis of which you say that it is a case of service, not a right to use.
Lordship, Lordship, the paragraph 95 of A.R. Lakshman's judgment in BSNL.
Again, you are coming to that. I know the law. Law we will apply first.
Lord.
First, let us see what are the basis on which you say this to be a service
Yes, your lordship.
and not a right of use.
Lordship, then I'll take your lordship directly to the lordship page 48 first.
Yeah.
Lordship, I first of all like to place the point number 2.5, 2.5.1, which shows that all the labors are been
Point,
2.5.
Yeah.
Lordship, it says the work to be carried out under this contract shall, except as otherwise provided in these conditions, include all labor, materials, construction, plant, equipment, and transport, which may be required in preparation of and for full and entire execution and successful completion of the works. Lordship, Lordship, what I am providing is my launch vehicle. Lordship, it goes on the Lordship sea, on the water. So in the launch vehicle, we supply them the my labors are mine. We supply them the materials. Their materials goes from one place to another. Their people goes from one place to another, and Lordship, all these things
that
which
we will
provide.
see from the, what are the basic, what is the work? What is the scope of the work?
Lordship, scope of work is Lordship at page 46.
Hmm. Yeah.
Scope of name and scope of work. Scope of work: hiring of 2 numbers of launch vessels in connection with construction of Bogeybill Bridge across river Brahmaputra near Dibrugarh for 2 years. The principal items of works are shown below. Higher charges per launch fitted with DG set for essential services. The higher charges shall include the cost of operators, machine, etc. deployed for running and operation of the launch as per the IWAI regulations, complete in all respect. Running charges of launch vehicle, including cost of all consumables, including the cost of operators, etc., complete in all respect. And running charges for 10 kVA DG set, including cost of all consumables, higher charges, etc., complete for essential services in launch vehicles. However, the details of items may please be seen in the schedule.
Hmm.
Lordship, this is my scope of work. This my launch vehicle, 2 launch vehicles I am going to provide
And
for construction, and this is in connection with the construction of Bogeybill Bridge across the river Brahmaputra near Dibrugarh.
Mm.
And that is for the year, for 2 years.
Mm.
Lordship, this 2 years was extended from time to time. I filed an affidavit that was extended from time to time. And Lordship, accordingly, this
And?
Lordship, page 48 is deviation.
yeah, what does it say?
A schedule of
So
deletion
there is a annexus C. What is annexus C? Where is it?
annexes to Lordship. Page 67. This is schedule, Lordship. Schedule of deletion or alterations by railway.
Subject to the completion of maximum calculation period. Okay, and these are all deleted.
Yes, your Lordship.
So how are you then?
No, Lordship.
So how does deviation have any real role out here?
Lordship, if there is any deviation in the, that means there is no deviation, Lordship.
You see,
Lordship,
this clause will only apply if is enclosed as annexure C.
Lordship.
If annexure C is not there, where is the deviation? You see, annexure C, all are deleted.
All are deleted, Lordship. There is no deviation in the contract. Lordship. This is what I
Okay.
wanted to say, that there will be no deviation.
Items as deleted in annexure C cannot be applicable to the tender contract. In case of alteration, the items as provided that be applicable to the tender contract. Was there any alteration?
No, Lordship, there was no alteration. Lordship,
Yes,
it
specifically
was
provided
extended beyond
otherwise in the
extended,
tender.
but alterations
These
were not
are
there.
all exceptions which the tender may have to a what is the basis of this deviation clause being relied upon?
Lordship, Lordship, I would like to show that Lordship, actually the deviations is not applicable on us, but this is a standard contract which they enter with everybody. Even if supposing I am giving the launch vehicles, if somebody is giving something else, this clause is a standard clause, and therefore there are various clauses which have no meaning, but still they are incorporated, because Lordship, like Lordship, there in the modification of drawings which is there at page 49.
Now that is not it. Now let us see 2.5.1.
Yes, your lord, 2.5.1.
Is the works and all you are to provide.
Yes, your
And
lordship.
this is within the scope of at number running expenses, consumables and all running on operation of the launch as per ICA regulations and all. So
Yes, your
this will come within.
Your
Then
lordship, the work to be carried out shall, except as otherwise provided in this condition, include all labors. So all the labors, materials, construction plant, equipment and transport, which may be required in preparation of and for the full and entire execution and successful completion of the works.
Mm.
The description given in the schedule of works shall, unless otherwise stated, be held to include carriage and cartage, carrying and hoisting, setting, fitting and fixing in position all other labor necessary for the full and final entire execution and successful completion of the work as aforesaid in accordance with good practice. Lordship, Lordship, the contract agreements, the clauses which are there, it is there in almost all the things. The specific, Lordship, the conditions which is there for the launch vehicles, Lordship, that is given separately. Lordship, may kindly see after, Lordship, specification is at page 72, which is specifically for the launches.
it is yes. That is special specific.
These are special specifications specifically in respect of launches.
Okay. Then
Lordship, over here, Lordship, it is described how the launch, what the launch vehicle should contain. Lordship, in this,
let us go to the objective area of work.
Lordship, the launch vehicle shall be operated from Bogibeel Ghat to Karangi Chapori Ghat on North Bank in connection with construction of Bogibeel Bridge across River Brahmaputra near Dibrugarh and any other project related locations as directed by the engineer. Operations of launches will be required at any time. Launch cannot be used by contractor for any purpose during the contract period without the specific permission of railway authorities. So we can, with the permission of railway authorities, we can use for any other purpose also. The purpose of launches is logistic support and temporary accommodation during transit. Lordship, thereafter, there are technical and special specifications of the launches. The launches supplied shall conform to the following specifications. Lordship, this specification that what are the lighting will be there, how the chairs will be there, the deck chairs, what are the things which will be there in the Lordship launch vehicles. Lordship, in this Lordship, page 74, point number 2. On some specific Lordship, I am just pointing out. Each launch shall be provided with a properly qualified master sarang and an engine driver having marine certificate, in addition to 4 numbers of khalsis and 1 cook who knows cooking well. For survey, inspection party and touring officers in the launch shall be provided. This is to be provided by us, Lordship.
Then
page 75, Lordship, point number 4,
three
page 75.
three is also same.
Three, Lordship. The launches shall be provided with adequate number of qualified crew having relevant statutory certificates which shall be produced for verification as and when demanded by the engineering in charge. In addition, adequate and suitable helping hands for proper operation of the various activities connected with the dredging shall be provided. Then 4, Lordship, the tenderer shall clearly indicate about number of launches, tugs owned by him or under valid lease agreement with other owner and shall furnish supporting documents for the same. Lordship, it is for the purpose that in case, Lordship, there is a defect in my vehicle, I have to provide with an alternate vehicle.
Where is that?
Lordship, that is at paragraph 17. Next page, Lordship. 76.
If
In case of mechanical defects or any other defects or safety reasons, the launch tug is not fit for further sailing, similar vessel with same facilities shall have to be provided in replacement under the same terms and conditions.
It is the important. So this therefore shows that it is a contract for supply
Yes, sir.
of the launch vehicle,
Yes, sir.
irrespective for doing a particular work, irrespective of whether that particular launch vehicle is A, B, C or D, but it
ABC.
has to have that specific.
Lordship, in fact, I filed an affidavit that it happened that they had but the launch vehicle which we had provided, they raised the railway raised an objection that it is not. There are some defects. Thereafter, we have given them the one alternate. Lordship, I have given the affidavit. In that affidavit, the papers are Lordship annexed. Lordship, then there is paragraph 14 also is there, Lordship. For 13 and 14, Lordship. Both 13 and 14. Routine repairs and maintenance. The overall work schedule is not affected. In total, maximum 48 hours may be allowed per month for maintenance of engines and other machineries, and payment for this period is allowed. The contractor shall bear the cost of running the engine or charging battery of the launch to keep the launch tug in tip-top condition with full voltage electricity. Engine RPM meter shall be provided in the launch, preferably in the wheelhouse. Lordship, Lordship, specific points I'm showing only to show that, Lordship, all the time, Lordship, my crew is provided by me, and all the time the control of the vehicle remains with me. Lordship, then page 78, I think. 78, page 78, Lordship. 77, the repeat.
Is it the concept based upon control, or is it the concept based upon the use?
Lordship, Lordship, as per the judgments which are of the Supreme Court, it is the control who in whose control the vehicle is that. Even the Lordship, the judgment Lordship referred by the respondent engineer as well as the KP Mojikar, the control remains with whom? That is the main purpose, Lordship, to show that transfer of right to use. If the control remains with me, I have not transferred my right to use the goods to him because the control remains with me. But if I have given the control to them, like in the engineer, Lordship, the judgment which has been tried.
Can't it be a complete package? I give you a complete package. Just look here. I think you supply me this particular vehicle in question for this 1 month and so on. And you bear all expenses. All is yours, but it will be under my control. I will do whatever. I
Lordship, if
The
suppose in
control
Lordship,
is upon whom?
Lordship, if
If control is your control is or subversive to the control of mine, or if I have the ultimate control, that yes, this vehicle has to be done in this manner. You are responsible for maintenance of that vehicle. It's okay, but merely having a right to maintain the vehicle, wouldn't that be a part of the contract? Right to you?
maintain the vehicle, Lordship, yes, the maintenance, Lordship, if Lordship, that what the judgment says is that we have to read the entire thing as a whole. Only one or two Lordship clauses here and there cannot decide the entire factor. We have to see for determining whether the control is there with me. We have to see whether
No,
the
therefore, are you
person-
saying the question of only control is the main factor to decide as regards whether it's the right to use?
Lordship, as per the judgment of A.R. Lakshmanan, that paragraph 95, there are 5 Lordship elements that he has given that which determines what is the transfer of right to use goods. If all the 5 elements are Lordship satisfied, then it is transfer of right to use goods. Like Lordship, in the case of engineering, they have transferred the license also to the respondent. The contractor, what they did is that when they gave the vehicle to them, they transferred their license also in their name for that specific period of contract. So now this is transfer of right to use goods because you have transferred your license also. So you cannot use the vehicle at all. The vehicle is completely gone to their hands, to the hand of the contractee for the specific period for which you have transferred your license also
So
to them.
would then that be a vehicle in specific?
Then it has become a vehicle in specific, Lordship.
So once it is a vehicle in specific, then it will be a right to use.
Transfer of right to use.
But
Then
if
we
the
can-
vehicle is not specific,
Not
therefore
specific.
the clause 17 has a lot of effect.
Yes. Yes,
So it is not specific. It is the contract which is the question,
contract
and of
specific.
which you have to give them 2 vehicles, of which the vehicle, if one vehicle goes wrong, you have to change it and give the same, a vehicle of similar
Similar
specification.
specifications.
So it is the the main edifice or the main stress out there could be a case where you have provided the services
Services,
of those vehicles rather than providing
goods
the right to use of the vehicles to them.
to them. Yes, Your Lordship. That is
There
the
is
thing.
that
The main element is not the vehicle. Main element is that I have to provide him the work with whatever ways
So
and
the
means I
main
can do.
element to or the distinguishing feature could be as to whether the vehicle in question is specific or not.
That's the main
If
question.
it is
That is
not
the main question.
specific to the vehicle, because tomorrow I may like to take a vehicle of a particular number, date, and so and so. This is the specific vehicle I wanted.
Hmm.
And he he allows me to use it. Wouldn't that be a right to use?
Yes, Your Lordship.
Whereas I say that you have to give me a particular vehicle for 1 month. I want a vehicle for 1 month, irrespective of anything. If you fail on this vehicle, you have to provide me another vehicle.
Another vehicle.
Then it is a service.
Then this is the- So there's a very thin line, Lordship, and that is why there are so many Supreme Court judgments only on one point. Whether it is a service or whether it is a transfer of right to use goods, because very
No,
very
that
thin
will
line.
depend. Therefore,
Depend on
all Supreme Court judgments, they keep on writing, that's a different thing. But the question is, every contract will have a different aspect
aspect
on the basis of the terms used.
terms.
But this is 17 is your main point.
Send it, ma'am.
Now let us see Motika judgment.
Lordship, KP Modika. Lordship, before that, there's only one paragraph of engineering, Great Engineering Shipping Limited, which they have relied on.
We will come to that.
Yes, Your Lord.
Let me first come up with it.
Lordship, my paper book which
Or
I have
you don't
provided.
want to even reply to what he wants to say.
Well, Lordship,
I
last
know I don't give the opportunity of replying, but then also I will give it to you, as it is on a Tuesday.
Lordship,
Yes. Where is your list of judgments and all?
Lordship, I have given the paper.
Give
Page 52, Lord.
Page 52. Yes. Where is
Judgment of
this
KP.
paragraph you are referring to? Yeah, page 30, paragraph 31, page 77. Is that
Lordship.
Lakshmana, this is
Lakshmana.
Lakshmana's concurring opinion?
Yes, Your Lordship.
Hmm.
That is the main thing. But Lordship, before that, Lordship, the submissions
Constitute
which
a
are
transaction for transfer of right to use the goods. The following transaction must have the following. There must be goods available for delivery, which it is there.
yes, Your Lordship.
There must be a consensus addendum as to the identity of the goods.
Identity of goods.
So this particular identity of that particular, the transferee should have a legal right to use the goods. Consequently, all legal consequences of such use, including any permission or license required therefore, should be available to the transferee.
Transferee.
This is your catch.
Yes, Your Lordship. It's with me.
For the period during which the transferee has such legal right, it has to be the exclusion of the transfer. And this, the necessary concomitant of the plain language of the statute, that is transfer of the right to use, and not merely a license to use the goods. Having transferred the right to use the goods during the period for which it is to be transferred, the owner cannot again transfer the same rights to others, which you say that with special permission you can.
Yep.
Now, Great
Lord-
India Eastern Shipping,
Yes, Your Lordship. Lordship, Great India Eastern Shipping Company Limited, Lordship, they have transferred the license.
now that is the judgment he is relying upon.
Yes, Your Lordship.
Yeah, and that was taken by Mudikar.
Yes, Your Lordship. Taken care by Lordship.
In commissioner, in Adani, in Field, it has been. But, yeah.
Paragraph 35. 35 at page 84. Paragraph 35 at page 84. And it the reason is that the transfer is therefore the test is C not to the business. Moreover, the conjoint between the process it appears the use of by way of only a policy. Now the printer is carrying out the work at the district level. Control over the delivery. That is the conductor for crew members for operating the train. It is the conductor who has paid for the fuel for maintenance of any loss or damage to the equipment of the conductor staff. Any third party can start when the test because not correct as something the factors as referred to above. Paragraph 36 social audit. But 35 is the main paragraph on which I am read. Thereafter, Lordship, various agreements where Lordship seen that yes, almost the same agreements are there. And finally, at paragraph 40, it was held that there is no transfer of right to use goods.
Yes.
Even though paragraph 42 is the concluding paragraph, but I
read
say
it.
35 is the main paragraph, Lordship, which decides what are the points
Yes,
which has to be
now
taken
come
into
back
consideration.
to his judge.
Lordship,
Yeah.
Great Eastern Shipping. Lordship,
Where,
paragraph 34,
where we given that?
Huh?
The judgment?
judgment copy. Lordship, may right.
No, no.
33 and 34. Lordship, Great Eastern Shipping Company Limited is 2023 SEC 354. Lordship, paragraph 33 and 34, I am relying on. At page 377, paragraph 34, 376 and 377. Mainly, Lordship, paragraph 34. Lordship, may I read?
Wait. You are in a hurry?
No, Lordship.
Tell me which paragraph? Which paragraph?
Paragraph 34, Lordship, mainly. I'm relying on both 33 and 34, but 34 is main, Lordship. Let the control. Expression let has been used.
Now kindly come to paragraph 33.
Lordship,
In our opinion, merely by providing the staff,
merely by providing the staff,
the
Lordship.
staff is not-
I am, Lordship, I am also, Lordship, only when that is also one of the consideration. But only that, only if you say that I'm providing
So
staff, that
is
is,
no longer important.
this is not the only criteria.
Insurance, indemnity, and other responsibilities of bearing the official costs. Effective control for the entire period of 6 months. It is a case of transfer of right to use the itself. For which certain expenses and staff are provided by the contractor. It is a case of the possession and control and possession.
Not sufficient, Lordship. Stated in the agreement. Lordship, after going through everything, paragraph 34 is very important. What is important?
This is the line.
Yes, your Lordship.
Permission license have been given, made available to the charterer to the execution of the contract.
Paragraph 34 lays down the specific reason for which they have this honorable court has held, the Supreme Court has held, why there is a transfer of right to use goods in this case. To constitute a transaction for transfer of right to use goods, essentially good must be available for delivery. In the instant case, the vessel was available for delivery and in fact has been delivered. Firstly. Secondly, there is no dispute as to the vessel and the charterer as a legal right to use goods, and the permission license has been made available to the charterer to the exclusion of the contractor. I have even transferred my license also to that person, to the contractor, and that is why it was held.
Paragraph 37.
Lordship, thus there is complete transfer of right to use good.
Paragraph 37.
Yes, Lordship. Lordship, 36 and 37, Lordship has to be read as a whole, because 36 is A.R. Lakshmanan judgment. All the 5 points.
Let us come to 37.
The charter party agreement qualifies the test laid down by this court, which is at paragraph 36, Lakshmanan's judgment, applying the substance of the contract and the nominal nature test. The vessel was available when the agreement for the right to use good has taken place. Vessel was available at the time of transfer, deliverable and delivered, and was at the exclusive disposal for 6 months for round the clock with the charterer porters. Use of license and permission was at the disposal of the charterer and the exclusion of the contractor transferor. It was not open to the contractor to permit the use of the vessel by any other person for any other purpose.
Kindly come to page 382,
Yes, Your Lord.
the last portion. It is a case of transfer of right.
It was a case of transfer of right to use machinery. High Court held that there was no transfer of right to use machinery in the absence of satisfying the essential requirements of Section 5E of APJ. What distinguishes the aforesaid fact case on the facts is that the effective control of the machinery, even it was in while it was in use of the contractor, was that of the respondent company. The contractor was not free to make use of the machinery for the works other than the project work of the respondent or move it out during the period of the machinery was in use. Condition was that the contractor was responsible for the custody of the machinery, did not militate against the British company's position and control. It was a case of hiring of the machinery for a specific purpose on specified hire charges. Charter party agreement is different in the present case. Lordship, this
Paragraph 41.
40.
41.
Yes, Your Lordship. It has been observed by this court in British India Steam Navigation Company Limited that whether a charter party agreement operates as a demise or not depends upon the stipulations of the charter party. In the case of demise, the charterer may employ ship in carrying either his own goods or those of others. A charter party has to be construed to give effect as far as possible to the intention of the parties as expressed in the written contract. When stipulations of the charter party are expressly incorporated, they become terms of the contract. There was nothing to show that the charter party agreement was by way of demise. Maximum pacta dan legem contractui has been relied upon, which means that the stipulations of the party constitute the law of the contract. The case was remitted for trial. The decision in British India lays down whether a charter party should operate as a demise or not. Depends on the stipulations of the charter party. Based on stipulations, we have come to the conclusion that it is a case of transfer of right to use goods, which is a deemed sale. The decision buttresses our conclusion that the charter party has to be decided based on the stipulations.
And paragraph 44.
Yes, Your Lord. We are not turning our decisions upon the terms used like let, hire, delivery, and redelivery, but on the other essential terms of the charter party agreement entered in the incident case, which clearly makes out that there is a transfer of the exclusive right to use the vehicle, which is deemed sale and is liable to tax under KST Act. In the instant case, full control of the vessel has been given to the charterer to use exclusively for 6 months, and delivery has also been made to them. The use by the charterer exclusively for 6 months makes it out that it is definitely a contract of transfer of right to use good the vessel, with which we are concerned with in the instant matter, and what that is a deemed sale as specified in Article 366(29) AD. On the basis of the aforementioned decision in SR Shipping Limited case, it was urged that all charter party agreements are service agreements. The submission cannot be accepted, as there is no general invariable rule law in this regard. It depends upon the terms and condition of the charter party when it is to be treated as only for service and when it is transfer of right to use. Depends on facts of each case. And Lordship, in this case also Lakshman's all 5 points were Lordship dealt with, and it was held that since they have transferred the license also to them, delivered the goods to them, so there's nothing left now that it is not transfer alike to. Lastly, it was submitted.
So, wouldn't it be a case where the goods was identifiable and one in which the goods cannot be identified on account of the requirement of providing the service of the in a case where the license is being transferred,
license is
it
also
has to be specific to a goods.
specific to that specific vehicle.
But if it is a service, or therefore the word used by the Supreme Court in Modika's case is license to use. There's a difference between right to use and a license. This is what has been stated in. So the law remains the same.
Law
There's no quarrel with that. But the question is on the interpretation of the term. Here, your case is on 17, wherein it says that it is irrespective. It is not the goods in question, it is the service which have to
Service
be
which I-
provided for giving two ships or two vessels for the purpose of carrying out this thing. And if one of the vessels is defective or has any problem out there, so that is immaterial.
Yes.
You have to provide another vessel.
Another,
It is the work which gets prominence than the vessel.
then the vessels. This is my humble submission.
Anything else?
And Lordship, one more Lordship submission I would like to make, even though it is not so relevant. Lordship, in other states also I am providing launch vehicles. It's not that only in state of Assam. Everywhere Lordship service tax is only taken. Nowhere VAT was taken. Because it is not the only two vehicles which I have. I have got other vessels. I am providing service in West Bengal, Patna. I'm providing everywhere. But nowhere Lordship,
Have
VAT
you
is collected.
filed cases there?
Lordship, because they are not taking only Lordship.
That is not a jurisdictional point for me.
Lordship. I am just Lordship referring this.
Other states may not, do, the state of Assam may be complained. Yes, now then,
My lord, already, my lord, paragraphs have been referred to in KP Modiga's case. I would, my lord, again read my lord, para 35 for a moment. What was the point or clauses that were taken into consideration while arriving at the decision? Para 34 prescribed the various clauses, my lord, which were part of the contract, which was before the Honorable Supreme Court. So 35 is the final finding.
Yeah.
On a conjoint reading of the aforesaid terms of the contract, it is apparent that the contractor has an option of replacing the cranes in case one of the cranes was not working properly. Only the contractor is liable to take care of the legal consequences of using the crane. The contractor
here
must,
also,
here also, my lord, these clauses are there. Otherwise,
that clause is there,
yes.
by which a contractor, 17,
Yes, ma'am.
in case of mechanical defects or any other defect or safety reason, the launching of the craft is not fit for further sailing.
Sir.
Similar vessel with same facility shall have to be provided in replacement at the same terms within 7 days.
My lord. No, they only, not only that, my lord. Lordship, my lord, may I read further? There is only one clause. Next is, my lord, only the contractor is liable to take care of the legal consequences of using the crane. We have it here also, my lord. And it is there in the, my lord, Eastern Shipping case also, my lord. That I will point out, my lord. The contractor must maintain the crane. And it is for the contractor to pay for consumables like fuel, oil, etc. Even the cranes must be moved and operated by the crew members appointed by the contractor. Moreover, in case of any mishap or accident in connection with the cranes or connection with the use of the crane or as a consequence thereof, the entire liability will be of the contractor and not of the ONGC.
Here,
Does-
here,
Yes.
here, whose responsibility? If anything happens,
My,
Of the contractor, my lord.
then
Thus, in short, the contract is, this is my lord main thing. Thus, in short, the contract is for providing the service of cranes to ONGC. The reason, this is the reason is that the transferee, that is ONGC, is not required to face legal consequences for using the crane supplied by the contractor. Therefore, the test laid down in clause C and D of para 97 of the decision of Dr. A.R. Lakshmanan are not fulfilled in this case. Legal consequence was the, my lord, consideration that was taken into, my lord,
where-
in
So here-
Modiga's case.
in whose legal, railway?
No,
Railway,
contract,
are you to bear any legal consequences for any
No.
accident happen? Who?
it's the contractor contract.
Here,
Yes, but now, my lord, may I point out, my lord, this same clauses in, my lord, the Eastern Shipping case.
but in Eastern Shipping case, the question involved out there was the vehicle, the registration or the license of the use of the vehicle was also transferred.
No, my lord.
Yes.
That observation though has been made, my lord, in this particular para 34. But, my lord, we'll have to see the clauses therein, my lord, which were taken into consideration before arriving into that, my lord, conclusion. Lordship will kindly see, my lord, para 25. Same, my lord, parameter clauses were there, my lord, in that. And my lord, the vessel was tagged. Here also it's same tag in this particular case also. Para 25, my lord, page 370. Thus, I will point out the my lord, parameter clause as well. Special condition of contract. All operational costs, including wages, minimum wages act or any other act, allowances, victualling, insurance, personnel, hull and machinery, protection and indemnity will be borne by the contractor. Repair, survey and other requirements to keep the tug operational will be to the contractor's account, and during any absence of tug from day-to-day duty or inability of tug to perform for this or any other reason will result in non-payment of higher charges for the period the tug was not made available to the charterer on pro rata basis, and clause 16 of the charter party agreement shall apply. On the date of commencement of the service, the tug shall have completed all the necessary surveys and be in possession of all valid certificates. Dry docking should not be required for a minimum period of 2 years from the date of delivery of tug on charter. A joint survey will be carried out. It's not necessary. 6, my lord. The charterer will not be responsible for any damage suffered by the tug due to failure of the tug or errors of the tug master and crew or any reasons whatsoever. The contract will be it's not important, my lord. 8, my lord, the tug shall have available for port operations round the clock throughout the contract period. Next, my lord, 10. Even 9, my lord, the contractor shall comply with Indian Merchant Shipping Act and any other legislation related to the operation of a tug in Indian territorial waters, and if of foreign registry, shall obtain the appropriate license, permission. It is the contractor will have to obtain from the Director General of Shipping, Mumbai, for operation of the tug in NMPT. 10. The contractor has to pay the revised minimum wages to the crew engaged by them. If the crew is engaged for more than 8 hours, they should be compensated for the extra work. This is important, my lord. Again, the contractor has to take the insurance policy covering all types of risks of all employees engaged by them. The contractor shall carry out the work strictly in accordance with the contract to the satisfaction of the deputy conservator and shall comply with and adhere strictly to his instructions and directions on any matter, whether mentioned in the contract or not. This is again important, my 12. The tug shall be delivered in 30 days from the date of issue of the letter of acceptance, is seaworthy and efficient condition, and should be in possession of all necessary certificates. Certificates are in the name of the contractor, but my lord, while delivery or delivery of this particular, my lord, vessel or in, he should have in possession of all the certificates. The contractor must have. It's not that it has been transferred to the, my lord, charterer. Next, my lord. 14, my lord. The contractor shall obtain necessary clearance as required from DP Shipping, Ministry of Surface Transport, etc., for deploying the tug for service in the port before the tug is put into service. So all the licenses are in the name of the, my lord, contractor, my lord. Only thing, my lord, he must have in position at the time when, my lord, the particular vehicle is placed with the charterer. Now, my lord, 26.
Come to clause number 16 and page
My lord, 2.
374, clause number 16.
My lord, penalty. If the vessel is inoperational or unavailable and the charterer are denied use of vessel, penalty will be levied from time and date of such in operation, non-availability after allowing any downtime to the credit of the contractors up to the time and date of breakdown in operation as follows. So and so. This is regarding penalty, but before that,
Very relevant. I am thinking what happened.
from the time and date of such incorporation, non-availability after following any downtime to the credit of the contractor up to the time and date of breakdown operational to 14 days, amount of percentage. In case of non-deployment of tug beyond 30 days, the contract shall be liable for termination at the discretion of the
Whereas in the instant case, if the vessel in question is not properly used, it cannot be used. They give the term that you can provide another vessel.
replacement. But my lord, that vehicle, whatever is replaced, will have to have all the my lord requisite licenses and all
Yes.
my lord.
No,
That part
that
is always there.
required.
It will have to
It
be,
will have the specification.
Yes.
There's no quarrel with that.
yes,
But that is the spec. But the question is, there is no termination,
my lord.
which is here. That is why I'm saying, here it's a case of a termination.
Lord.
Therefore, specific to the vehicle.
Yes, but that part,
There's the problem, and that is what on that day also I say. If you, the question is, yes, exercise can be, you can interpret this way, that. The question is whether it was specified to the vehicle, or if it is specified to the vehicle, then in that case, it is a right.
my lord, here the petitioner has placed the my lord page, lordship may kindly turn to page 76 of the petition.
Yes.
Lordship will see my lord, page 76, the last clause is 23.
Mm.
Then my lord, 77 again, my lord, clause 3, repetition of the earlier page.
Lordship, this is a.
No, let me complete,
mistake.
let me complete. Now, my lord, page 78, again 35 comes. From 23 to 35, the clauses are not there.
Page 78, Lordship.
Yes, yes,
Is
I'm
there-
coming to that.
Page
So, my lord, in page 80, there are two contracts, my lord. Page 80 is the second contract. There, lordship will find, we don't know whether the same conditions are there or not, but page 112, lordship may kindly turn to page 112. 111, my lord.
Yes.
111, para 20, here, my lord, clause 23, then 24, and 25, may lord read it. The tenderer shall clearly indicate about number of launches available with him for contract
And
and
this is there earlier also. This clause is very much there earlier also at page 76. Kindly come to page paragraph 14. Paragraph.
no, after
Paragraph number 4 at page 75.
25. But that's why I'm saying, well, so far as this particular, my lord, next 112, my lord. My lord, 31, may I read, my lord? Clause 31. The launches shall be physically taken over by the engineer's representative after the same is mobilized to the place mentioned in the schedule of this contract within the stipulated time and found satisfactory and in accordance with the specifications and conditions laid down in this contract. And as recorded during the initial inspection by the authority, the engineer in charge will thereafter issue a certificate in this regard, indicating the date of taking over. Higher charges shall be payable to the contractor from the date recorded in the certificate as mentioned in serial number 8 of the special conditions of contract. 33, my lord. The launch shall be dehired on expiry of the period mentioned in the schedule, respectively, until the same is extended by the engineer in charge in writing prior to expiry of the contract period. Mobilization or demobilization charges shall be paid only if the relevant terms and conditions of agreement are carried out successfully.
Where is the penalty?
My
If
lord.
he does not provide any of them. There's no penalty. Therefore, 16 becomes very relevant.
17.
That
16 there.
That 16, you see, because that is specific to the vehicle.
My lord. There is no option for replacement therein, my lord. Here is the option for replacement. That is the other.
Therefore, it becomes the same. You see, why in Justice Lakshmana, paragraph 97A,
My lord.
there has to be goods. Meaning that the goods could be identified. Not only that particular good has to be identified.
But my
And
lord,
their right of use of that good.
my lord. No, here
Here-
also, my lord, as per this clause, my lord, when it is replaced, the vehicle will again be under control of the my lord, particular railway only, my lord. It will be under full control.
Absolutely, it will be replaced, but the fact is, it's not specific to the vehicle, which I made it on the yesterday or day. It has to be specific to the vehicle. It is not.
My lord.
That is the main consideration. You see, therefore, on interpretation, here, what the Supreme Court said in that shipping corporation judgment, that here not only that, the license was also given, thereby to show that you cannot use the vehicle for any other purpose. Here you can use it with special permission. Meaning thereby, it is not again to the vehicle in question. It is the question of the reason why you cannot use, or the understanding out there in the contract for you that
My
you
lord.
cannot use, that it should not disturb the work for which the service has been taken. Yes, Mr. Bishop.
I'm preparing for the performer respondents number 6 to 8.
You are the person who has deducted the amount.
We have already paid it to the government of
So who is going to return the money to? You are going to return, or you have deducted them?
government, because it's in the coffers of the government, my lord. If it's required to be refunded,
Illegally deducted. Now, would the government be liable for it?
my lord.
That's a very important consideration. Isn't it, Mr. P. Gugoi?
Right.
Where hold it, would the government not be liable for interest on that?
My lord, the government will.
Whether the government would be liable for interest of the amount? Because that is statutory.
That part, my lord.
No. Why I have to think about it? I'm not going to pass that order. But the question arises. Tomorrow, the moment I say in their favor, they will come up there with interest, and the next petition is coming.
Yes, sir.
You can have the second petition in your hand now only. So the responsibility isn't it of the railways to pay the interest?
They are the one who deducted.
They deducted without going into the. Did you ask them before deducting?
My lord, there was some demand, I suppose, my lord.
Huh?
Probably for, but I'll have to confirm that. I'll have to confirm it. Probably there was some demand from the authority. So that is
Today
why,
is what day? Tuesday. I'm having it in Thursday for another purpose. You file an affidavit bringing on record the entire contract. Then I can make it clear. Because without that, those 2 pages are missing.
Lordship, actually, the pages is not missing. There is one extra page. Lordship may kindly see. I will file an affidavit again, but Lordship may kindly see page 48. The pages are there. Actually,
Page?
78. The page is there, Lordship. There is an extra page which has been annexed. 77 is an extra.
Madam, kindly see page 75. 75 starts with 3.
Yes, sir.
Then
Again,
ends with 12.
Yeah.
76, 13 to 23.
yes, sir.
77 is
Oh, yes,
starts
yes.
from
Again
again 3
three.
to 12.
Yeah, Lordship.
Then,
78 is.
and then kindly see. This is finishes at 23. And then 70
33.
it starts from 35.
I will, Lordship.
So being an equitable judgment, the discretionary jurisdiction putting the repetition with the case.
Yes, sir. For
So what do you want? Dismissal on that technical ground, or
No,
do you want filing an affidavit?
I'll file an affidavit.
It's the matter on
Affidavit, fine.
during the course of a hearing, it was noticed that the agreement entered into the by and between the petitioner and the railway, which have been enclosed as annexure annexure 1 is not complete in as much as the entire set of the special specification is not available. Ms. L. Havelia, the learned counsel appearing on behalf of the submit that the petitioner file an affidavit by tomorrow, bringing on record the state affidavit state agreement in total in the entirety and placed before the court. List the matter again on Thursday.
Lordship, can it be on Friday because tomorrow is a holiday, Lordship? Tomorrow is Saraswati Puja. I can file on Thursday, Lordship, no problem, but it will not come on
List the
record.
matter on Friday. Thursday. Fine. I wanted to close it,
Yes,
but I wonder, bring it on record that
Lordship, otherwise it is also because now, Lordship, I have filed an affidavit in which, Lordship, the railway have given a objection that my vehicle is not fit. The annexures I have provided, not fit, so I have to replace it, and I have replaced it, Lordship. There is a, Lordship, I have filed an affidavit on.
why
That may
are
be taken.
we going into our next editing? These are facts. Let us go on the question of how you filed that from
Much approved.
Friday at the top of the
Much approved.
hearing is complete, Mr. Gogoi. Only that I'm only allowing that, but otherwise the technical aspect I hear not.
But even in that penalty.
And you give me a photocopy of the judgment.
Yes, Lordship,
And also this Motika, I think by now it has been reported.
reported. Lordship.
So get me a reported judgment of Motika and the shipping corporation. one.
Much.
Item 2 and 3, top
You
of the
give
list.
me together on that date.
Yes, Lord.
Yeah.
After 30 years of fighting, they have agreed to pay 1,43,000.
Yeah.
Let them release it.
We have filed the affidavit, my lord. We have calculated
Fund
that.
is available to disperse the amount of the tape. Now, but I give him the opportunity now for claiming interest.
Interest we have already calculated, your lordship. We have filed the affidavit, my lord.
Where is the interest?
My lord, paragraph 4, my lord.
Where?
Paragraph 4. of the affidavit, my lord.
1,15,288.
Total amount, my lord, compensation amount is, my lord.
What is the interest calculation? On what basis? 9 or 15?
My lord, first year 9% and my lord, after that, my lord, 15%.
Total calculation.
Calculation sheet, my lord,
So we'll have it on Thursday. Thursday, at the top of the list, you produce the calculation.
calculation, lord.
And Mr. Sharma, you just have a look at it or take it. Otherwise, the payment has been made.
My
No,
lord,
not yet.
Payment,
payment will make, my lord, ready, my lord, will make as, lordship, if your lordship direct now,
Is
day
the-
itself, my lord, we.
we'll have it on Saturday.
Sir,
We have it on Saturday. On Saturday, by that time, payment.
Lordship, maybe please to object.
Saturday, my lord, I got to visit,
You are
appointment with doctor.
present.
I just operated.
No, it's okay. Your presence is not required. Let the amount be paid. If I see that the calculation has been done as for 9 and 15, I'll close it.
Yes.
And
My lord, with the liberty, if you dissatisfied, go to district judge.
if the amount is less,
Yes.
and he will only produce this,
Yes.
and you have given the bank details
My lord, he may be provided the bank.
during the course of the day. Can you give the bank details of
Bank
your
details to
petitioner?
go file during the course of time.
We will have it at 2. It's matter now. We'll have it at 2.
Yes.
Okay? Today. You ask your person to get the bank.
And my lord, can I
And,
call for
and
the
if you can get the
calculation, my lord? My lord, that would be better, my lord. Yes. Oblige.
It can be disbursed today itself.
we
Lordship,
can
Lord-
finish the
Lordship,
day.
Okay.
Lord, oblige.
Okay.
For admission, item 4.
Tricky. Okay.
Lordship.
Yes, what is it?
My lord, ওই তো তোমার করে পেতে কিন্তু কল করেছি
Today they have filed an affidavit, my lord.
Ah.
I'd just like to Make a response.
The nature respondent shall apply it to buy the petitioner will not be entitled to the return of 5/4 of the third hand, as well as also the. So this is the affidavit file. You've gone through it.
They have filed today, my lord.
Okay. You want time?
My lord.
How much?
12 days time. 12 days we will file a response.
Huh?
12 days time we will file response in the meantime.
Mr. Your name?
As from my
As per my appearing on behalf of the petitioner, submitted that the revenue as well as the district administration.
Madam, we have not filed affidavit. Earlier, we
Only-
filed, madam.
Who has
Not
filed the
today.
affidavit?
Today
It is
filed
one security so and so revenue.
Today filed a-
Revenue is what? And oh, the revenue.
Not-
The Revenue and Disaster Management Department has filed an affidavit in opposition today. The copy of the state affidavit in opposition is available before this court. The learned counsel for the petitioner submits that he may be given some time so that he can take appropriate instruction. Accordingly, it's the matter on 7th, 7th March 2024. In the meantime, the respondent, the petitioner, if so advised, would be at liberty to fight with time
my lord.
by
My lord.
Fixing the product if machinery in working place is considered to be as eligible component for the purpose of subsidy under so and so. The structure other than above not considered as eligible component. While miscellaneous fixed assets are not eligible component so and so for the purpose of PCS, however, electrical components are essential for plant and operation, which are connected to the plant. So and so. The point where finished goods are produced, dispatched, and are associated with the manufacturing process are considered to be as eligible components. The components of PNM for which payment has been made in case by the industrial unit are not considered while assessing the PM for the purpose. Based on the definition of PM, the scheme notification, subsequent clarification, and recommendation of the technical committee considered eligible for subsidy is enclosed by exhaustive list of eligible. So this is already my perspective. This is not
now earlier, which were the exclusions and inclusions?
my lord. Yes. Dear my lord, next my lord.
You are the manufacturing, page 126.
Yes. My lord, that is 29 of my
Plant and machinery, 0.6,
Okay.
phase 120.6.
Now, what have they done with this?
Now by 133, they have clarified.
So it was only 6, 1, 2, and 3.
Yes.
So on the basis of 6, 1, 2, and 3, were you entitled to these? Were you entitled to the commodities which were excluded as
Yes.
per 6, 1, 2, and 3? At page 126. And this being a case of promissory estoppel, there has to be specific averment in that regard. That as per 6, 1, 2, and 3, you were entitled to, because this promissory aspect has to be pleaded. It cannot be in vacuum.
No, my lord, these are my lord, the plant and machinery at page 126, my lord. In calculating 5% cost of industrial plant and machinery as erected at site will be taken into account, which will include the cost of productive equipment such as tools, jigs, ties, molds, insurance premium, etc. Everything is there.
Now, Lordship,
The amount involved in the goods carrier to extent they are actually utilized for transport of raw material and marketing the finished product will be taken into account. Working capital, including raw material and other consumable will be excluded. Well, this is only excluded. Definition of plant machinery and components should be taken into account for the purpose of this scheme in respect of service sector biotechnology. So, my lord, this is broad, my lord. Now, my lord, if you also see, my lord, at page 37 of my account.
You see clause one at page 126 or whatever maybe it is.
My
your-
lord.
it's your,
Yes. In this pilot, there is no exclusion.
You have filed an affidavit in reply.
My lord.
In your affidavit in reply, have you made out any ground for that?
Yes, my lord.
In
Para
your
9
repeti-
and 10, my lord.
in your repetition, it is completely silent
Well, para 9 and 10, my lord, I have to.
of the repetition. Of your-
No, affidavit reply. I've given that.
Nine is what?
169.
Type of affidavit you have filed, half of the page is not missing. If you look into what affidavit you filed, kindly come to number D, E, read page E.
E.
There's no page number also.
Oh, yes.
172.
I'm sorry, my lord.
Read it, what is it? It is stated herein that though the respondent at the affidavit have annexed the so-called report from the grant of capital,
I'm sorry,
central capital investment,
sorry, madam.
NEIP 2007. Can you read it?
This page, my lord, and this page, my lord, completely.
See, your entitlement was as per 126. But there is no mention as to how 126 have been diverted. 126 stated only the basic thing.
My lord.
Why we can't say that this document at 25/2/2013 is a document which had clarified or not for the purpose, it had prescribed what was there in page in
Well,
clauses
well,
6, 1, 2, and 3.
My lord, my submission is this, not a critical, my lord.
No, your submission can't be done
No.
unless you have stated in your pleading, because this is a case of promissory estoppel.
Well, that is what I have
Then
said, my lord. That
it
is
is
what I
not
have said, my
there.
lord.
How can I help you?
Yes, that is what I have said, my lord.
Where?
Yes.
Show me that.
Yes,
That 6, 1, 2, and 3 granted you certain things
yes, my lord.
which
That-
is being excluded in 25.
My lord, that is,
And
that is
how?
my lord,
And they have not challenged
You take your seat.
PIC that PIC is report.
Not necessary. Let us
My lord-
see, let us go on a better
my lord, para 20 page 21, my lord.
page. Para 20.
Yes, prior to that also I have said, my lord, but this is my lord. It is not,
20 years
I mean,
denial.
submission, state also they are not expected back arbitrary at the suitable pleasure. Point of the state to grant benefit, but state granted benefit under 2007 policy by functioning the state to change the operational guidelines by purportedly laying down specifics on eligible and ineligible components of plant and machinery in the special plant, which was not specified in NIP 2007 nor in CCS 2007, issued by notification number 72, and declining the personal benefit that it was not entitled to, and prisoner have also submitted the claim within the prescribed time. On the contrary, to duty of the duty and the obligation of the state to ensure that the promise made under the policy are translated into action as per policy framed for purpose and is issue of a matter. The clarification that issued on so and so and revised operational guidelines issued on so and so are liable to be interfered with to the extent that specifying eligible and non-eligible components for the purpose of PCS, national plant and machinery and the respondent are liable to be directed to grant the prisoner.
Anyway, what is your judgment? I've looked into it. It appears to be a prima facie, it appears to be a case where they have prescribed what was there, what was required to be done in terms of clauses 6.1, 6.2, and 6.3. And there is no averments to that effect in your affidavit. I understood in the petition not be there, but in the affidavit also it is. Anyways, what are the judgments you are relying upon? Let's see. Whether it's a case of whether if the main clauses are vague and it has been done by way of a notification or operational guidelines, it has certain details have been incorporated. Can that not be applied? To me, that
My lord,
that it cannot be.
my lord, my humble submission, my lord, that on the basis of the my lord guidelines of 2007, I've established, I've changed my my lord.
You have changed. There is no quarrel that you are not eligible.
lord.
But the question is here whether you are eligible as per the original one or what has been prescribed later.
My lord, if this application would have been considered, my lord, within time, my lord, then my lord, there's no question of my lord, 2013 coming into court, my lord. Because I established
You
the-
submitted on 19/11/2012.
2012, my lord. 2012.
And within what time do you expect it to be considered?
My lord, because
This
DIC has
notification has come on 25/2/2013.
Yes.
How much time do you expect that it will be considered when you take almost more than a year, almost a year to file your application? Tell me.
My lord, only thing my humble submission is this, my lord. I have, my lord, established a unit as per the existing guideline, my lord. These guidelines, my lord, will not be
And
applicable.
Mr. Sahiwala, the
Ah.
question is very clear. You are entitled, you are an eligible unit. There is no quarrel with
My
that.
lord, my
But the fact as to whether when the original or the policy out therein only mentioned 6, 1, 2, and 3. In that, whether the notification or the operational guidelines dated 25/2/2013
30.
would show that it is a prescription to 6(1), 2 and 3, or is it a something else which have been brought in to deny you the benefits which are there in 6(1), 2 and 3? That is the question.
My lord, in fact, my lord, the original guidelines is very exhaustive, my lord. My lord, actually, they have stated, my lord, but if you also see, my lord, that what's the inquiry they have to done here as per the original guideline. Yes, my lord.
Kindly come to it. Page
Right.
126.
No, I'm just, my lord, before that, my lord, you also see.
This is the guideline. Page
Uh,
126 is the guideline.
Ma-
Notification
the
of 27/7.
Page 37, my lord, the guideline, your, my lord.
Page
Page 37 of my picture.
No. This is based upon this notification
No, that's
of 20. You see,
Here-
the operational guidelines is based upon this notification.
Yes.
Of 27/7/2007, which have not been enclosed by you. This is the
2007.
basis on which the capital.
No,
subsidy
2007, I have
is
entered,
taken.
my lord. At page 29, my lord.
Huh?
Page 29.
Page?
29. It's a 27th of July.
This is it.
Yes.
6(1), 2 and 3.
Yes.
Now, whether 6(1), 2 and 3 stipulate certain things which have now been excluded.
My lord, page 30, my lord, extent of admissible subsidy, then clause 6, my lord.
That is the clause 6. That is why I am saying.
Yes.
That case has
So
to be
here, my
based
lord,
on
they have
the-
excluded some item, clause number 3.
Huh.
Others, everything has been included, my lord.
In
in-
calculating the plant of machinery, the cost of industrial plant and machinery as directed at the site will be taken into account, which will include the cost of productive equipment.
Yes.
Such as
Tools,
tools,
jigs, dies,
dyes,
molds,
mold,
insurance premium,
insurance
etc.
premium, etc.
My lord, this
The
is
amount invested in the goods area to the extent they are utilized for raw materials and marketing of finished goods will be taken into account. Working capital including
this is
raw
excluded.
materials and other consumables stores will be excluded.
Yes, this is
For
only excluded.
computing the value of plant and machinery. Now, what do you mean by working capital, including raw plant and including raw materials and other consumable stores?
Yes.
What do you mean by that?
The working capital, my lord, the raw materials which purchased, my lord, and these boxes and other things which I prepare, my lord, these bags, candy bags and others. These are the consumables, my lord.
Yes.
So these are not
What are here? Working capital, including raw materials.
Yes.
What are the raw materials
raw materials, my clinker.
and other consumable stores?
Yes.
What is consumable
This,
store?
my lord, the consumable stores are, my lord, gunny bags and others, my lord.
Huh?
Plastic bags and others.
Plastic.
But these,
These are all these things are taken at page 96.
Hmm.
Workshop equipment. What is workshop equipment? How can it be included? Laboratory equipment.
yes.
Equipment for power distribution other than those at G6. G6. So G6 duly permitted electric and control and instrumentation equipment along with software for fluent equipment for power other than those at G6. Equipment for water supply. firefighting equipment, mining machinery.
Well, these things, my lord, not coming here, my lord, in this matter. Here, my lord, these,
Storage buildings like silo,
yes,
hopper, stockpile. What are
Yes.
these? Silo, hopper, stockpile.
these are excluded, my lord. They
So what
appear.
is a hopper? Hoppers, hopper. What is that?
I think that in a chain, my lord, from this, the goods are taken up, my lord.
Huh? No, no, no. That's a conveyor belt.
See, my lord.
Take a container for a loose bulk material such as grain, stock, or rubbish.
Yes.
Typically one that tapers downwards and is able to discharge its contents at the bottom.
Yes.
The lorry is waiting under the hopper to pick up the load. Okay. So that means these are the ones which pick it up and then throw it up.
Yes.
Rubbish. Silo is what?
Copper is a funnel cell container from which solid materials can be emptied into container bin.
Yes. So therefore that is
Yes.
silo. But this has to have a reference to the
The essential, my lord, items of the interest.
no the moment whether it is essential or not, that is the question again coming within the ambit of challenging the note. Silos are there, no? Where it is kept out. But there is no challenge to this communication. Are you challenging it?
My lord, I say that it cannot be, it is retrospective, my lord.
But
That is what I
are you
think.
challenging it? No.
In that, my lord,
So
that is what I,
the intent or the legislative or the intent of the authority
my lord, my prayer was
include
that it can,
certain things within the ambit of exclusion, which ought not to have been excluded, is not a subject matter of judgment.
my lord, the future aspect, my lord, so far future industry, my lord, I cannot feel that. I say that, it cannot be given retrospective apart from that. That is what I am saying.
Now, therefore, your aspect is 25 is okay, 25(2) is okay, but the only thing you cannot apply it there,
Yes.
because if you apply it, other benefits are due.
Well.
Anything is that
Judgment, my lord, these are the, this, they relied on again, modular program for 2016 6 SCC, my lord,
2000?
16 6 SCC. Another one, my lord, this, latest, my lord,
Yes, what is it?
my lord, paragraph 12, my lord, 12, 13, 17, 19.
Have you looked into the written judgment?
Recent, my lord, I'm just giving one. That, even 23, 10 to
Have you looked into the
23,
judgment on
10,
Indo Hero Photocop?
well, right there. I have come, my lord, to 23, 10 SCC 62.
Ah. That is by Justice,
No, no,
Chief Justice,
Justice, Chief Justice, my lord.
recent judge. Yes, the old one, recently. Tell me,
My lord, there are 25, my lord, they find, my lord, building on Motilal Park.
Kindly come to paragraph 40.
Yes. Applying the above mentioned principle in the case, we are unable to achieve any substance the submission of the state, which has urged the defense would have. Not only the state, in the current case hold out a solemn depression, and this depression was founded on a stated desire to encourage industry in the state. The policy document listed the incentive, the period on which incentive will be available, time limit will be which follow-up action will be taken by the state government. So department implementation. Instead having held a solemn depression in the above term, it would be manifestly unfair and arbitrary to deprive the industrial units within the state for their legitimate activity. The state government did, as a matter of fact, issue a statutory notification under section 9, and but by doing so prospectively with effect from 8/1/15, it negated the nature of the depression which was held out in the industrial policy of 2012. Absolutely no justification bearing on reasons of the policy or public interest has been offered before the High Court or before any court for a delay in issuing an order. The pleadings are completely silent on reasons for a delay on the part of the government and offer no justification for making the exemption prospective. On the contrary, the terms of the repression held out in the industrial policy of 2012. One thing that state had the Krishna had no vested right, but quite another for the state assert that it is not duty bound to disclose its reasons for not giving effect to the exemption notification within the period that was envisaged in the assessed position as well. Both the accountability policy and document of mitigate against the accepting such a notion of the state power. The state must discard a colonial notion that is sovereign handling out the roles at will. Its policies give rise to legitimate expectation that the state will act according to it what puts forth in public. In all its actions, the state is bound to act fairly in a transparent manner. That is an elementary requirement of the guarantee against arbitrary state action under Article 14 of the Constitution. A derivative of the entitlement of the private citizen and private business must be proportional to the requirement of ground in public interest. The conception of state power has been recognized by this court in the context of national building construction. The government and department in ensuring the affairs of the country are expected to honor their statement of policy or intent and to treat the citizens with full personal consideration without any iota or abuse of discretion. The policy statements cannot be disregarded unfairly and applied selectively. Unfairness in the form of therefore, it's clear that state has made a request to the respondent and similarly situated the industrial unit under the interest policy 2012. This request gives rise to a legitimate expectation on their behalf that they would be offered 50% rebate reduction on electric duty for next 5 years. However, due to the failure to issue the notification within the stipulated time and by grant of exemption only prospectively, the expectation and the trust in the state would violated. Since the state has offered restriction for the delay, notification or provided reasons.
Yes, any other judgment?
Sorry, madam, this is
Here
the
was the
latest.
case, there was a delay in issuance of the notification.
Yes.
Any other judgment?
Well, the earlier judgments are there, madam. We all know.
Yes, put your say.
As far as
Who is going to pay?
okay,
Who is going to pay?
central government. Yes,
Here the central government who has paid.
so far this notification of 25 to 2013 is concerned, is that verification notification. It doesn't take away anything, which has been, it is there in the notification of 2007, either of 1/4/2007, the original policy, and Northeast Industrial Investment Promotion Policy of 2007, and subsequent notification of 27/7/2027, 2007. Sorry. So, it was just clarified. The conditions which was laid down in the 2007 notification is just clarified that. And other aspect, because as it involves the use of public money, is a public money, so the department has to look into, it has to evolve a mechanism, so that this what is the
What
This-
happened to those industry units
yes,
who have been earlier granted to apply immediately thereafter?
but they have
Well,
accepted.
You have considered up to
Yes.
2013 and then such applied.
Yes.
What about the other?
Locals,
Constitution.
yes,
So the
prior to
proposal of-
2013, but I don't have any instruction on that.
No, it is apparent from the document itself. So there were different persons giving different things.
Yes, yes.
So under such circumstances, you have to come with a clarity.
Yes.
So it is apparent from the reading of that document that the various departments were, various state agencies were giving.
Even the
different-
banks, man. Even the banks which have supported their project, my lord, even they have given different figures. I can show from bank
That is
represent
apparent.
reports.
The state agencies were also giving different.
Yes, yes,
So now you made it as a clarification.
my lord,
If we see 6.3
my lord.
at page 150.
Yes.
It shows which are to be
My lord.
How do you exclude the Sito or the Hooker within the ambit of Sito? Because it has to be.
Yeah.
If it is a clarification, then it has to be excluded within the ambit of Sito.
But plant and machinery is not exhaustive.
Kindly come to 6.3.
Yes, my
Read
lord.
6.3 at page 150.
Yes, my lord.
What
Working
does it say?
capital, including raw materials and other consumable stores will be excluded for computing the
Would be
value of plant
excluded.
machinery.
Would be excluded.
Yes, my lord.
How do you bring in the exclusions which are there?
Well-
The 25 with what? 2013. Within the ambit of 60. How big? Then only if you can
Yeah.
bring it, then you can say that it is clarified. If it is not, then are you not then interfering with 6.1 and depriving somebody who had set up on the basis of the 2007 of that amount? And then you have said that it is not prospective. How do you take care of that? Okay, I think he has finished. You say,
But my lord, here all I am relying on judgment, my lord.
Mr. Odhikari,
Well,
that
well.
is the, that is the,
My lord.
can you bring those exclusions within the ambit of, if you cannot,
My lord,
could you not be interfering?
Well.
That's the point.
my lord.
If you can bring it, it is a clarificatory. Obviously, you can.
Well.
Because you on your own say that it is not retrospective.
Well. Well.
Therefore, you are saying it to be prospective. Now, what will happen to a person who set up on the basis of that? And you have come up with the exclusion now. Has to be on the basis of something. So you have to bring it within 60.
Well.
You can't, the matter is finished. The Sahewala without showing a proper judgment is that of
Then, my lord, I will prefer some time, my lord, so that
Huh?
I can
What?
get some clarification on that,
But clarify.
how it was done, my lord. Again,
Wait, your industry department fellow will help. Yes.
Lordship.
How do you bring the exclusions in 25 2030 within 6?
6.3 lordship, I mean, it will be difficult for
If you
silos.
can't bring them. Would you not? It can't be a clarification.
The lordship, as far as what my submission will be in that context, lordship, that's 6.1.
Which one is okay?
6.1
Each one
says,
gives what are the plans and machinery he is entitled to.
correct,
But it does not exclude. The excluding clause is 6.3.
correct, explain for 6.3.
6.1 says that whatever plans and machinery he will get.
That's what, lordship, it's not an exhaustive list. It's not an exhaustive list that has given, and we do not know what are the plant and machineries he hasn't brought in record. What are the plant and machineries he has claimed for? Now, certain plant and machineries, I mean, it can be from the very on the face of it. It may not be plant and machinery that we do not know, that he hasn't brought in, and that has to be scrutinized by a specialized team.
That is
Correct.
not,
Yeah.
Mr.
So now,
Mr.
yes,
Goenka,
I
this
I understood your
rest
lordship
assured,
theory.
this court is not going to go into those.
Correct.
The only thing, the only point of law involved out
Yes,
here
yes.
is can you bring, would the reading of section 25(2) document, or more particularly the exclusions, come within the ambit of 6.3? If it comes within the ambit of 6.3,
That finishes, Lord.
then otherwise you will be incorporating something in the year 2023, 13,
13.
whereas he has entered into commercial production.
I understood, Lord.
That is the only crux.
They only-
There's nothing else.
But as far as Lordship, working capital includes raw materials and other consumable stores. Consumables stores will be excluded. So working capital including raw materials will be definitely not to what will
Yes, these are not raw
these
materials.
are not raw materials. That's correct. These
So
are not-
therefore, can you bring the exclusions which you have made? Now you have made the exclusions not on the basis of the earlier, but you have categorically stated that the exclusions are made on the basis of the notification dated 25(2). Very well, you can. But the fact is, when he had come up before this court, and he had already went for his commercial production on the basis of a notification of the year 2007, which did not specifically exclude these. By way of a clarification, you can exclude something which is already there. Can you exclude something else by way of a clarification? I don't think so.
That's correct.
If you cannot, then in that case, wouldn't he be entitled to be considered on the basis of
What
the
is there in
investment
2007?
made without taking into account 25(2)? Others, that is the only declaration this court has to give. And thereafter you have to consider.
But
That's it.
Lordship,
I'm not going to, don't expect this court is going to look into all those things. I don't have the time and energy for that. I'm only, if at all, the only direction which this court is going to make is that
yeah, Lordship has already pointed out, Lordship has rightly taken into account about the policy decision, why the policy was changed. That clarification note Lordship has already seen. And only thing is that Lordship, I mean, as far as this clarificatory note, notice also,
so by way of a clarification,
Lordship,
Mr. Kolta, you just submit, and by way of a clarification, you can add something which does not come within the ambit of the original. You
Yes,
can
can I-
clarify something which is there.
yeah, my only humble submission will be, Lordship, it seems the exhaustive list was not there. Because the exhaustive list was not there, there were a lot of confusions. Because of the confusions, only the clarification notice come. Now, because the exhaustive list was not there, so that they have come up with a clarificatory note. And clarificatory note, Lordship, not only states about the exclusions, it states about inclusions also. It says about A and B, Lordship has seen that.
No,
Lordship has seen that.
therefore, there's no doubt. But the question, therefore, is, can you exclude something by way of a clarification of a term which is not?
No, that is what I'm saying, Lordship, that 6.1, under 6.1, they may be able to probably give some kind of clarification saying that these things are not included. Because
No, very well, they can.
That's-
But when you have 6.3, which minimizes the scope of
But
6.1,
if-
how do you take care of it?
if your Lordship sees, Lordship, the 6.3 is little bit different, Lordship, in a different context. 6.3 says working capital including raw material and consumables. It doesn't say about the plant and machinery as such, Lordship. It talks about the consumables. I mean, while making cement, you will require stones. So stones are consumables there and raw materials. So it talks about that, Lord. It doesn't talk about plant and machinery as such. So while reading Lordship,
Yeah. And it is working capital include raw materials and others
consumables,
included for computing the value of plant and machinery.
correct.
So while computing the value of the plant and machinery, you are taken out.
So raw materials has to be taken out.
Now you have taken out silos. Now the silo is a
In
part of,
storage.
silo is a part and parcel in a cement manufacturing plant.
Absolutely.
whereby you require those for the purpose of mixing. The question is of the hooper. The hoopers out there is required for removing the rubbish. Now, if it is not brought in, the reason why it is not brought in, you can also see from the exclusion list that you are taking out those things which are not a part and parcel of the plant and
The
machinery.
manufacturing process.
Yeah, the manufacturing process, but you are taking, but the surrounding things which are required or the peripheral area, you are removing.
No, correct.
Therefore, you see all these things. Just for example, if you see, let's say this one is 95, what you have removed out here, you can see workshop equipment.
Yes.
These
sir.
are peripheral.
Correct. sir.
Laboratory equipments, which will also is peripheral.
Correct. sir.
Equipment for power distribution other than G6. So G6 is required that these are connections to the TX.
Connections to it.
But you are removing the tube lights. You say, no, this is outside. Equipments for water supply, which is no required for supply of the water, but the water which is being given is included. Firefighting equipment, which is peripheral.
Right.
Mining machinery, which will be required, it is out. Easy set is outside. So therefore, what you are doing is, you are only having the plant and machinery, which is the inbuilt thing. Now you have therefore to submit before this that this plant and machinery, which is given under 6.1, is the plant and machinery which is the composite one. It is the heart and soul of the factory.
Correct.
And nothing to do with anything which is peripheral.
Peripheral, ancillary things.
The ancillary is not out. Therefore, it has been clarified. If you can bring that or make that submission, then you can bring it within 6.1.
So Lordship, that is my humble submission will be as Lordship has seen it. I mean, different agencies, different states, and different bodies who are basically recommendatory bodies, while analyzing and scrutinizing this, these claims, they have given different,
They were bringing in other aspects.
other aspect. So now that the 6.1 was not clear, Lordship. 6.1 was not clear because in calculating plant, they have said only plant and machinery, the cost of industrial plant and machinery as deducted site will be taken into account. So it was not an exhaustive list, neither an exhaustive list was
But
given.
what do you say? Such a tools.
SAS is tool. That's what Lordship.
The tools is included.
That's what.
Now, if
Tools,
the tools are
jigs.
included,
No.
no, if the tools are included,
No.
whether
Lordship, this is not only for cement factory, Lordship. This is not only for the cement factory.
Okay.
This is for plant and machinery for other projects also.
Hmm.
So that's why Lordship, they have written it tools, jigs, dies, etc.
and why it was given for C for year, A is for plant and machinery for the purpose of central.
So cement is it's not specifically for cement, Lordship. That's why all these things are coming. So different factories, those tools have been included. Now, Lordship, my humble submission will be since this plant and
What is
machinery.
annexure A? I mean, kindly come to page 25 too. What is annexure A?
25
Is annexure A a part of it? Of this document?
page, Lordship?
Page, kindly come to repetition, page 94 and 95.
94. Is 94 is that clarificatory notification 94? Then 95, Lordship, they have given justification why they have done so. 95. That A annexure A, Lordship, there are several companies, industries they are showing. Therein, Lordship, financial institution, how appraisal has been done, district industries, how they have recommended, state level committee recommended differently, then empowered committee has come to a different conclusion. So that is why all these ambiguities, Lordship, as far as the recommendations, they have issued this. And they have stated this while issuing this in paragraph, first paragraph. of it.
Where is the reference from annexure A, E in that particular document? If we have to read the 7/5/2020 original guide.
Which one, Lordship?
This is the operational guide.
Operational guidelines, they come up subsequently. Yes.
Where is the reference in 7/5/2023 to annexure A, B, and C?
7/5.
Page, kindly come to page 90.
Ninety has been done subsequently, Your Lordship.
So the 90, in page 90, the
Yes.
annexure is that 25/2. It is annexure B to page 20.
Actually, this is not the whole document.
Reference to I.
This is not the whole document, Lordship, that has been annexed.
Yeah. Kindly come to page 91. Usually, Roman 28
Yes, Lordship, I will usually SLC organizes that.
field visit to the unit before considering the claim.
Claim.
In case of claims under the central limit requiring approval of empowered property union for claims above where the concerned state government must deny. Field visits of the team by a team consisting of one representative each from A, the state government, each as well sector, unit for an illustrative panel of administrative ministry, department, autonomous bodies is included annexure A and B is
Net.
NEPI. So annexure A is this. Then the functions of the field visit is this. Kindly come here. The functions of the field visit shall be broadly to verify. Then number 3, 4, to suitably explain the deviations in the value of plants and machinery considered eligible for subsidy from the appraisal report.
Yes.
The deviation report shall be submitted as per the format given in Annexure C.
Got it.
The C. Annexure C is this. Page 96. Okay. Now kindly come here. Number 31. While recommending approving a claim under the scheme, the SLC shall consider the following. Now kindly come to 1, 2, 3, 4. Clarification on eligible components of plant and machinery provided by DIP from time to time. The latest clarification provided by letter dated 25/2023 that closed as Annexure B.
Correct.
So
Yes.
this 25/2 happens to fall here.
Correct.
Okay, now Annexure A is where again,
Annexure A is place 95.
now Annexure earlier there was any clarifications given prior to that, because here you use the word clarifications of the eligible components of plants and machinery. Is it something to do with this? Kindly come to page 95.
Yes, Lord. 95.
Components to be included for computing the value of plant and machinery
Yes,
and
sir.
the
So that's what I'm saying, Lordship. They have given two exclusions as well
and
as
when was this given?
Lordship.
When was this given? This is very relevance out there, no?
The cost of plant and machinery, including taxes, all these things is given by this 25th notification.
Huh?
25th notification.
In 2018, there were any notification. There was an 18 in notification. 2008.
Opportunity list what I say. Lordship, 2012, there was one,
Very good.
page,
Because this will have a relevance.
correct, Lordship, page 94, if your Lordship sees the first paragraph, then Lordship will see, this refers to notification issued by a Department of Central so and so on 7, wherein components of plant and machinery and scheme are defined. Subsequently, instructions have been issued by letter dated 2/11/2012 regarding computation of plant and machinery on the basis of appraisal report of financial institution which funded the project.
So are we to say this 2/11/2012 has something to do with this page 95?
Yes, Lordship, it looks like. Because they have issued another notification on 2/11/2012.
This 2/11/2012.
So that is not on record here.
Hmm.
So we are
You
not.
produce it,
Central government.
produce that document.
Why not?
2/11. Because then is it
Then
is
computation.
page 95, that document, part of page 95 is 2/11/2012. You can check it in the internet, you will get it. There's no problem with
We'll
that.
check it.
Get it. But anyways, ask it. We'll have it on Thursday or Saturday to conclude the hearing. After so much, giving so much of time.
Monday.
No, I'm not there. It is on Saturday.
My father is having a scientific birthday. I'll be out of
When?
on Saturday.
Fantastic. Then on Thursday. Just find out that document. Mister, you can just find it out in the net.
I'll try to.
We'll get it out there. There's no problem. And Mr. Saiwala, you also try to find out. We'll have it on Thursday.
Yes.
Hearing almost complete. Now, the parties have duly been heard. This court, however, finds it relevant to find this court, however, would like to have a look at the notification of 2/11/2012 referred to in the notification dated 25/2/2013 before concluding the arguments. This is the matter again. Right. Otherwise, the hearing is complete.
Not well.
And then get that judgment on unicorn
And hero contact. I'll get. ठीक है, सर, thank you. Thursday. Friday को लेने के last Thursday. Last तो और Friday में Friday करो Friday हमारे
একটু দিলবা ভাল নেকি
Friday को मोरा बहुत मैटर है Thursday बहुत मैटर है सर खोलो को Friday को Thursday पूरा Friday কি জানে মোৰ Saturday আছে আপোনাৰ এই বাজেট হ'ল Thursday মই কৈ দিলো এটা মই উঠা ক'ব নোৱাৰো Friday पहले कौन से तो कंपनी का आते दिया पूरा खुद ही पड़ गई खुद ही पड़ कोई ना आई नहीं 18 Ako Friday ko ka Friday la usually ko ko to ko Friday ko kaile ko he ako no bile bole ayo Friday और सुविधा बड़ी कोई फ्राइडे को
You got the bank detail?
My lord, he is a daily earner, my lord. He was not available. He might have gone somewhere.
One requisition has become useless, huh?
Yes, man.
Which one?
The second one, my lord, that where the land, return of the land is demanded, there is no
Huh?
4719,
4719 is infructuous.
Lordship.
Is it infructuous?
Yes, my lord. 4712 is
12 or 19?
19, but taking a return of the land is becoming factor. In your
19,
19.
my lord.
19.
Now your lordship is taking up 4712.
12.
19 has become infructuous. Has been submitted as a part by. Has been submitted by Mr. Party after that the instant requisition has become infructuous, taking into account the above. The report repeats that by the order dated 24/1/2024, this court had directed the Special Secretary to the Government of Assam, Revenue and Disaster Management, as well as the Deputy Commissioner Kamrup Aminda, to file an affidavit as to when the amount would be paid and what steps have been taken by the authorities concerned as regards by the state authority against the concerned official as regards the delay in paying the compensation to the petitioner. On the basis of the said directions, two affidavits have been filed. One affidavit is filed by the District Commissioner Kamrup stating inter alia that the amount to which the petitioner is entitled to for 2 kathas of land have been duly calculated along with interest. And the said amount upon being determined is rupees 1,43,688.
Lordship.
During the course of the hearing, the details of calculation have also been placed, which is separately kept on record and marked with the letter Y. The records further reveal that the Deputy Secretary to the Government of Assam Revenue and Disaster Management Department has also filed an affidavit pursuant to the order passed by this court of 24/1/2024. Wherein it has been mentioned that on 3/2/2024, a letter was issued to the District Commissioner Kamrup to take immediate action for payment of the awarded principal amount of the compensation, as well as to take up the proposal for payment of interest on the awarded amount in the related LA case. Due to the delayed payment of award as per the provisions of law. It has also been mentioned that the said deponent, by another communication dated 9/2/2024, directed the Deputy Commissioner Kamrup to submit a report to ascertain the responsibility for delay in payment of the compensation to the petitioner. However, the said report is yet to be furnished. This court, during the course of the hearing, also inquired with the learned additional senior government advocate representing the state respondents as to when the amount of rupees 1,43,688
388.
would be paid to the petitioner, taking into account that the same has been duly ascertained, and the calculation which have been done also shows that the interest has been calculated as on 12/2/2024. When
Matlab immediately. Lordship, if it, matlab the petitioner gives the furnished bank details.
the learned counsel for the respondent, district administration submitted that within 10 days from the date the petitioner furnishes the bank account details of the petitioner, the same would be disbursed to the petitioner. Taking into account the above, this court therefore disposes of the instant petition, thereby granting the liberty to the petitioner to submit the bank details to the Deputy Commissioner Kamrup
Kamrup, I mean,
District company.
District Commissioner Kamrup. Forthwith. Upon submission of the said bank detail, the District Commissioner Kamrup is directed to release the said amount, disburse the said amount to the petitioner. After carrying out due verification within 10 days from the date of submission of the said bank details. This court further finds it relevant to take note of that an amount of 1,15,288 had to be paid as the interest on account of the delay caused by the concerned respondent authority in making payment, which has to be defrayed from the public exchequer on account of the negligence on the part of the state or on the part of the erring officials. This court therefore directs the Commissioner and Secretary to the Government of Assam Revenue Department, Revenue and Disaster Management Department, as well as the District Commission, Kamrup, to make an inquiry into that aspect. And if on inquiry it is found that on account of any negligence on the part of some officials, the interest amount of rupees 1,15,288 had to be defrayed from the public exchequer. The same be recovered from the dues of such erring officials.
Liberty, if the person not satisfied with the amount, you may take the recourse to the 1894 Act.
No, here the amount was, why have you approached this court? Only for payment of the amount,
Yes,
not for the purpose of anything else.
because if he feels that well, this is amount is less or lesser, then he may take the recourse, madam, even after the defraying of the amount as calculated.
So this ascertaining of the amount was done when there is an affidavit being filed.
Is on 12/2, correct?
Hmm?
No? Bharat ji.
No, no. Amount.
Someone able to say Bharat
No.
ji. Yeah, right.
This award is passed now. Huh? This is the awarded statement is now.
This
as it can
calculation,
be. This court also finds it relevant to observe that the award of the amount of rupees 1,43,688 was passed
12,
12/2.
12 to Bharat.
on 12/2024. Under such circumstances, if the petitioner is aggrieved with the inadequacy of the compensation, the petitioner can very well, would be at liberty to approach the authority seeking a reference in this on the question of determination on the question of inadequacy of the same could be done within the prescription, within the period prescribed in the law, taking into account that the date of the award is 12/2/2006.
Available.
Huh?
Principal thing.
Apply.
Yes,
Supplementary
Mr.
item
Mishra,
19.
your matter.
Supplementary item 19.
Hello, your lordship, author.
Because this matter is now connected with the other matters which are
Nine.
there.
Yes, but
Long-
mine will take some more steps we'll have to take.
Yes.
Because
Any affidavit has been filed?
no affidavit. On 23rd, your lordship passed an order asking them to clarify whether Paschim Boragaon falls within the municipal area.
Yes, what have they done?
Yes, on 23rd. Now
Hmm.
they have given a copy
Yes,
of the map.
That has been.
They have, but that there is a map, there is Paschim Boragaon, but they say it's municipal area. So they will have to file an affidavit. Because if my lord will kindly take up.
But the GMD shall apprise this court as to whether the revenue village is included in the Guwahati matter in terms with the notification to the constitution. Or is there any other notification issued in that regard?
Now, my lord, since they will be filing affidavit, I must tell my lord, one thing they will clarify there at the page again. Your lordship kindly have Guwahati Municipal Corporation Act 1971.
Yes.
I'll read section 1 and section 1, subsection 1 and 2. This act may be called Guwahati Municipal Corporation Act 1971. Your lordship got it? Except as hereinafter otherwise expressly provided, it extends to city of Guwahati. Now your lordship will come to section subsection 9 of section 3 at page 4.
Yes.
City of Guwahati or city means the area within the boundaries to be specified by the state government on this behalf and duly notified in the official gazette from time to time as required under section 42 of this act. So they'll have to, my lord, produce notification on which date Paschim Boragaon was included in the city of Guwahati. Only then municipal act will apply and then they will have jurisdiction over that area and contiguous to the area.
No, the contiguous, you see, why I said this was another respect. On the last occasion, while the hearing was going on, you submitted a thing to the effect that they have put this in the composite zone.
Yes, yes, they
Remember?
have changed the user.
To composite zone.
Yes.
Whereas, that is why the other matters have relevance today. Because that Paschim Boragaon, they have put, you see the map, the city that last
Item 20,
there's a
item
series.
20 to 27.
You see an affidavit where they have put a colored map, wherein they have put Paschim Boragaon out there and put it as an eco-sensitive zone.
Yes, but in this regard, Lordship, I would like to clarify that eco-sensitive composite, these land use don't allow. These are DAG basis, not on the basis of area. This particular DAG is eco-sensitive. This particular is eco-friendly. This is composite number 2. This is composite one, like that. Not as an area.
No, but when you put that map, you didn't say that. Only see that map. In this map, which you have put out here, you have put this particular area, which falls in Paschim Boragaon.
Lordship, I have given one map, Lordship. That is the map of the GMC law. Here your Lordship will see the Paschim Boragaon as
within the GMC area. One ward number 10 is here during the on the left side, Lordship. On the left side, Lordship will ward number 10, one purple area is there, Lord. One purple area is there, one red line is there. On the both side of the red line, Lordship will see below Lordship, Paschim Baragaon, above Lordship, Bamunpara, Paschim Baragaon. Ward number 10.
Betkuchi is public, semi-public. Then
is
you
after
have the
change.
next, the green one. This is the GMC map.
Yes. This is the ward map of GMC. Heading is there, Lordship. Ward map of Guwahati Municipal Corporation. Top left. The map your Lordship is seeing, Lordship, on paper, this is the GMDA map, must have said.
Understood, but there is one area which is different. Like, for example, the green portion of the map just next to the Betkuchi. If you see,
Yes,
you see? Is it available out here in your that computer?
Yes.
In that monitor, it is available?
No.
Okay, anyway. So next to Betkuchi, you have a green portion. Dalboma. Now this Dalboma area this is the Dalmoma. Then comes Paschim Baragaon. Paschim Baragaon, you have to do that what? Ward number 10.
Yes, sir. In the GMC map, it is ward number 10, that purple area.
Now, if it is purple, this Paschim Baragaon is otherwise, you are saying it to be a eco-sensitive.
No, this is ward map, sir.
No, it's okay.
Yes, Paschim Baragaon is eco-sensitive. Eco-sensitive and eco-sensitive. Lordship, in fact, Lordship, in these matters, Lordship, in terms of your Lordship last order,
You have filed affidavit.
on 8, we submitted one affidavit.
Okay, okay.
But raised the decline to accept the same.
Why?
Because your Lordship, they're pointing out that in your Lordship order, one error is there because the department is wrongly mentioning animal husbandry and veterinary.
Oh, is it?
So that is why they have not accepted.
This what? Okay, good to hear.
It is what 10. Yes, what
Which repetition it was?
2746.
Oh, so as per you, it is false. Paschim Baragaon is ward number 10.
This is GMC. Yes.
So automatically 3-1 it is there if it falls within it.
92 notification.
So, but for that you have to come up with that notification under section 42, some notification to the effect when it was included.
For this, for the purpose of this map, section 42 PMC Act.
Ah.
But for JMDA Lordship, it's section 3, 1992 notification.
No, that
No, that is
is
okay.
different.
GMDA, it's okay. For this matter, the matter of Mr. Mishra, that is 3-1. But 3-1 will automatically cover within it. because of the fact that if it is within the GMC area. But for the becoming a GMC area, you need to have a notification under
They
40.
furnished me this map lotted, and they are saying that it is from the very inception, Paschim Baragaon was within the TMC area lotted.
So then also there will be some
Yes,
notification.
that notification I can.
Yeah, you just- Ticket was 1352/2014. During the course of hearing, Mr. P. Naik, the learned counsel appearing on behalf of the GMDA and the GMC, submitted a soft copy of the ward map of the Guwahati Municipal Corporation, wherein the area in question, that is in Paschim Baragaon, wherein the petitioner's factory is located, have been included in the GMC, within the within the city of Guwahati. Mr. D.K. Mishra, the learned senior counsel, submitted Mr. D.K. Mishra, the learned senior counsel, drawing the attention of this court to section 1 and subsection 9 of section 3, had submitted that for including an area within the GMC, there has to be a notification in terms of section 42 of the GMC Act of 1971. In as much as Mr. P. Naik, the learned counsel appearing on behalf of the GMC and the GMDA, submitted that on the next date he shall produce such a notification, which shows, submitted that the area of Paschim Baragaon have been included within the city of Guwahati since its inception. Is it?
Yes, no, that is.
And he would produce the materials on the basis of which he had made the say submission on the next day. List the matter again on when?
One.
Have it on 12th
12th of
March?
Well, we can have after 14.
19th of March? On
Well,
19th of
One more thing which I would like to add, the Lordship remember, the notification of 1992 by which they have issued my lord greater Guwahati municipal area, metropolitan area. That includes even across Brahmaputra, North Guwahati. It goes up to Suwal. And my challenge to that notification is also there.
So for that you have to file a PI.
No, why I'm saying,
You have no business out there for other purposes.
no, I'm not, what I'm. Your
I
Lordship,
now remember, Mr. Mishra, why the matter, I have asked them to clarify on 3.1
Yes.
of section 3.1 now, because of the fact that in that notification of 1992, Paschim Baragaon was not there.
Yes.
Therefore, I asked him, how is it possible that Paschim Baragaon was not there within the GMDA?
Can you Lordship,
Yeah,
Lordship take up the notification of 1992?
because that revenue
At
village
page
is not there.
72.
That is why he's now come up with that take, that it is already there in Guwahati.
But it is connected with that, I'll also show to your Lordship, but your Lordship kindly come to 72 of the writ petition for a second.
Yes.
This here one, there.
Because here that village is not there.
Page is not there.
The village, the revenue village of Paschim Baragaon.
No, serial number 1 lot.
Revenue, no,
Guwahati
it
Municipal
is,
Corporation.
That is why he's now coming up that it is a part of the Guwahati city itself, so not necessary.
No, my lord, your lordship will say it includes Guwahati Municipal Corporation
Hmm.
area, whichever were available in 1992. It also covers North Guwahati Town Committee area, then other revenue areas as shown below. Now, my point is that had they issued notification within the four corners of GMC Act or Section 4 of DMDA Act, because they exercise power within the limit of the Guwahati municipal area or the contiguous area. Had they confined their order to that, there would not have been any question of shifting the industrial area outside Guwahati, beyond North Guwahati and to Swal. So this had a effect. Because we are our challenge is to the change of user zone. Industrial area, they have made it composite area. So my challenge is to that. And one of the ground of challenge is that had they followed the law, they would not have gone beyond their municipal area and contiguous areas. So no question of shifting this industry to Swalkuchi. That's why I'm saying that 92 is also a challenge, and I have specifically made a prayer in the writ petition regarding this. So therefore, your lordship, in my humble submission, your lordship may have to go into this. I don't need to file a PIL for it.
How are you affected?
I'm affected because they have got a space, so they have shifted the industrial area there, and mine one become composite. The concession that they have made that the existing industry will stay. But what about expansion? If I expand, there will be complaint that it is you cannot expand because this is only for existing this thing, and the commercial zone is there. People will be affected. There will be pollution. So it's directly affecting me, an expansion of my factory.
So therefore, the question would be only as regards the composite area, whether you could have made it composite or
That's
not.
right. If
That
no,
is the exercise.
so, if they have could not make composite area, the area would have remained industrial area.
Whether it
That
should
is-
have been composite or industrial, that is another question, which
But I
obviously
have,
this court,
my
no, this court will take note of that.
that,
That
that,
I am
that's
going.
enough. That's
But
enough because
but not as regards the other aspect, because this is not a part of the challenge.
no, correct. I will confine
Because-
whatever is under challenge.
Because
That is, I-
if we go into the question of the North Guwahati aspect where you don't have your industry, therefore I am saying that it will come within the ambit of a
my
PR.
lord, I will only make my submission to restricted to the pleading that I have and how I will explain how I have been affected because of that.
So I think this order, this will.
Yes, yes. They'll file an affidavit, my lord. That should be made clear, my lord.
They bring a
Of course,
gazetted.
notification,
if they
your lord.
Bring a gazetted notification, I think that would suffice.
Yes, that will suffice. Lordship has not fixed any
Yes,
date.
the other matters,
Your lordship has not fixed any date.
Item 20 to 27.
it will have 18-1. In the order dated 18-1-2024, it was inadvertently mentioned that the affidavit is required to be filed by the Principal Secretary to the Government of Assam Animal Husbandry and Veterinary Department, which ought to have been the Principal Secretary to the Government of Assam Guwahati Development Department.
No, now there is a new department, my lord. Now that has been merged into, I'm just indicating, Guwahati Housing and Urban Affairs Department.
It's a Department of Housing and Urban Affairs. The DDT has been merged with
It should have been by the Principal Secretary to the Government of Assam,
Department of Housing and Urban Affairs.
Department of Housing and Urban Affairs.
Lord, may kindly make it Commissioner and Secretary. Principal
Commissioner. So they said official. It therefore directed to file the affidavit as regards the difference in the use of the land pertaining to eco-sensitive zone and eco-friendly zone, eco-sensitive inverted eco-friendly. And further, as per the master plan, whether the eco-sensitive zone is constituted. List the matter again on same day.
Same day.
19/3/2024.
Interim order will continue.
Interim order will continue.
Develop.
Alright.
Here, in these cases, whether this Pushim Boraga will fall within the,
Eco-sensitive
here the issue is whether it is eco-sensitive or
or
eco-friendly.
eco-friendly.
Now, if it is eco-friendly, you can take a permission for construction.
Exactly.
But otherwise, your
In the
construction is
affidavit
illegal.
filed by them, they have indicated that stand. In the affidavit filed by them,
Ah.
which is not on record, they have taken that stand.
What?
That with the permission, it can be done.
No,
The
that they can
existing-
do, but whether,
In
what is
both-
the
In both
difference?
eco-sensitive as well as in eco. Well, eco-sensitive is basically confined to, my lord, water bodies and all,
Water bodies.
low-lying area.
So that is the clarification,
Yes.
then we can make it very clear.
Yes.
But otherwise, you don't have a case.
Right. Regarding the first point, no case.
Alright.
Deeply.
Item 19.
May I please, your lordship?
You filed an affidavit.
Lordship, may I pray Malak to fix Saturday or Malak some other day to file the affidavit? I'll file it.
When?
Malak, Saturday, maybe fix on Saturday.
Huh?
Saturday, Malak, 17.
Saturday.
Maybe
filing?
I'll try my best. If your lordship, if some more time, Malak,
Ah,
Fine.
filing.
lordship,
What is the urgency?
lordship.
Urgency is there?
Because
Yes, lordship.
Okay. Is the matter again on? Not parted, na?
no part.
Is the matter again on 28/2/2024?
Deeply obliged.
The affidavit, it was directed to be filed by the order dated 22/1/2024, 24, be filed on 26th of February 2024.
Deeply obliged.
For hearing item.
May I please lordship? Here also, we are directed to bring the record of sale case number 508/1970 of this. Some more time required, lordship.
The whole matter,
Yes, lordship. Record also old, so cannot trace, we cannot trace stuff. Some 2 weeks time required.
as per what the learned junior government advocate appearing on behalf of the respondent, request for an accommodation so that the record as sought for by the order dated 4/1/2024 can take matter again 14th of March. In the meantime, the records as sought for by the order dated 4/1/2024 be procured without fee.
We have also filed an affidavit. Last occasion we have submitted that we also filed an affidavit to bring on record regarding the same matter, some repetition to file. We have already filed also yesterday.
S.K. Gupta may further submitted that he had filed an affidavit in the instant repetition. However, the state affidavit is not on record. The registry shall also bring on record the same.
Public.
Well, I'm interested to refer to file.
Huh?
What external file? 4. Not we about PM happen. The record of 4, right?
Right?
So that is it. More than-
Report. So many things.
We have to substitute.
Auction purchaser.
No, no, option purchase, I am a purchase. He was the original landlord, original co-partner. There are 5 bighas of land, out of which 1 bigha he, Godadhar Bhuiya was there. Other partner has not challenged the revenue option. Only Godadhar Bhuiya has challenged.
He died.
He died.
Any death certificate, nothing. Huh? No, no. Have you got any death certificate? So tomorrow, if you are not so, let us fix it on that day. You take it up.
Otherwise, I have to substitute. Otherwise, I have to substitute.
We'll see on the death. Produce the death certificate or something. Something has to be seen that he's dead. Otherwise, it becomes a big problem later on. I say it, then you are nowhere to be seen. Then he will substitute against somebody who's dead. Who's not dead.
Item 10,
Yes.
Lordship, matter may be fixed now, other than
Huh?
matter may be fixed now, other than
Why? What is this matter, Mr.
It is a dispute between two brothers, my lord, pertaining to a land, my lord. But
By reading the nature, tertiary should not be issued, and the order directing heir to hand over the possession of the disputed
is what-
land to the heir should not be set aside.
my lord, we had initiated and proceeding under 145 of the CRPC.
Hmm.
Where possession was declared in favor of the respondent. That was in 2001, man. The series of appeal, we filed an appeal, then we came before this honorable court. It was rejected. That was in 2006. Finally, the revision was dismissed. Then what happened, my lord, in 2008, the respondent number 3, who is the executive magistrate, she visits the site, my lord, and says that I find that the respondent is not in possession, the petitioner herein is in possession. So in terms of the earlier order, you hand over possession. That is not permissible in law. That I challenge in a suit, my lord. The suit is still pending. There was no injunction was not granted. So again in 2015, my lord, the order is set to be revived and a direction is issued to the police that please vacate the land and hand over possession. I am on that limited point.
When the suit was pending.
Suit is pending. Suit is still pending.
What is this? Nothing doing. Who are you?
And
They're
I
paying for
put
whom?
respondent number 5.
5.
So, when a suit is pending, what business does the 145 proceeding have? You are paying for whom? Who is your senior?
SPK.
Where is he?
He's on Lexington port number 26.
Port number?
26.
Nearby. Don't worry.
Lordship, we have used the file also. We have used our file, Lordship.
Oh. Show me that order.
Which order, my lord? The first order?
The last order which we are challenging.
The impugn order, my lord, at page 64.
64.
64.
And I'm closing here with a petition filed by Subhas Advocate.
Had there been a decree of the civil court in execution of some decree, my lord, possession is taken over from me, my lord, no difficulty. But here the initial order, your lordship will find the order under 145 at page 100, my lord.
And there is no answer in the affidavit filed by whoever has filed it. Who is this?
Lordship is looking into the government affidavit.
Who is this? I am discharging as a subdivisional officer.
Subdivisional.
He
There is
doesn't say anything about that.
No, my lord, nothing.
It is also a fact that a petitioner filed title suit number so and so and Iman wherein they was dismissed. And subsequently an appeal moved by the petitioner and it was dismissed by so and
That is admitted, my lord. I had moved a prayer for injunction. That was not granted, my lord. The appeal was also rejected, but the suit is
injunction
pending.
for what?
That against the order of 2008, my lord, similar order by which I was directed to
Where is your plaint?
my plaint, my lord. My plaint lordship finds at page 23, my lord. And the prayer portion is at 32. Well, it's a Exonia land, my lord. Annual patta land. I'm not praying for a declaration of my right title interest.
What type of suit is that?
Exactly.
I can't help you.
My lord,
You should have filed a suit based on, not on based on title, based on possessory title.
exactly. And in
Yeah.
fact, my lord,
What type of suit is this?
my lord,
You are asking, you are challenging an order.
he should have come to the High Court. My lord.
Huh?
He should have come before this court.
Yeah. Which
Because
order you have
this
challenged?
order, my lord, lordship finds it at page 80.
No, yeah, you have challenged the order of 19/1/2008
8.
somewhere. You have already challenged that order.
Yes. That order is not under challenge here, my lord. I am challenging
I understand.
my lord.
Here, this is a compliance. There is direction to comply.
Direction to comply in the sense, ask the police to vacate.
Whatever may be,
My-
but then also that is in pursuant to a direction
Yes, yes, yes.
under 145.
No, it's not
140
under 145. That is the difficulty, man. 145 order is at page 100, man. If we go chronologically, my lord, 145 order is at page 100.
Page 100.
Page 100. Lordship may come to the operative part at page 103, my lord. Last paragraph. The first part is Sushil Vasudev, who is the petitioner, my lord. The first part is Sushil Vasudev in his original petition does not mention anything about the cultivation of mustard crops over the DL. DL is a disputed land. But the witnesses adduced for both the parties in their evidence reveal that there is cultivation of mustard crops over the DL. However, he stated it in his evidence, which do not support his original petition. It means he had no actual knowledge about the DL in the time of filing of this case by him. PW to Sunil Vasudev demanded that he had purchased the
this
DL.
order of 2001.
My lord,
And what is this suit of? Another suit of 1998.
that is between the other two brothers, my lord. I am not involved there.
Why you are enclosing then?
Because there is a deposition, my lord. There is a statement made by the brother at page 131, my
No,
lord.
no, this court is not going to look into all those.
No, man, this I am not.
But the fact is, there was a direction not to disturb without following the due process.
My lord.
Now you have not to, so you should have filed a suit for recovery.
Not only that, my lord, not only that. If he is also, suppose, my lord, I have dispossessed him. For a moment, let us assume that I have dispossessed him. So he has to file a separate suit, my lord, or a 145 proceeding. Because the 145 proceeding does not empower the magistrate to restore possession and debtor after so many years, my lord. Possession is declared in 2001 in favor of the respondent, admittedly, ma. In 2008, the the judicial executive magistrate, my lord, makes an inquiry and finds that I am in possession. Now, in the going back to the order of 2001, in 2008, can the magistrate direct that possession should be handed over? That is the question to be answered.
He cannot take.
That is what I'm on.
Because
that.
144, 145, 145 has to be stated the date of 2 months
2 months, exactly.
from the date of the case. And they could have at least filed it for
They could have filed
section 6.
section 6. I am on that, let the rights of the parties be decided, but the executive magistrate, my lord, cannot
But your
evict me.
suit has no meaning.
Suit has got no. That I understand.
Okay, that will take some week, Lord. Next week, Lord.
No next week. This matter will be disposed of on Saturday in front of you. You want the second copy? I will. Or you take my copy. I will dictate it without only seeing of both of your case.
Letter may be fixed on Friday, Lord.
Saturday.
On Saturday, my senior will not be able to come.
I don't require. I have given you an opportunity today. I'm not going to give you on Saturday. Matter ends there. The Saturday is Saturday. The senior cannot come. You argue. Okay. Matter having been heard in part, list the matter at the top of the list on Saturday. After we set aside that. Unless you say these type of orders, you want to do, you want file suit, whatever you mean, and you have got to stay.
I've got it.
You got to stay.
Yeah.
2015, these type of matters are Monday, Tuesday matter. Monday, Wednesday.
Item 11.
Hey, please, Lordship.
Hmm.
Lordship, in this matter, I've just been informed that we are party in this matter. We, in this case, Lordship, we actually don't have any brief, Lordship. We have been appointed on, it's a very old matter, come after a long time. Formally, there was change of guard, Lordship. So therefore, my Lord, I pray for accommodation, Lordship. I can create a file, Lordship, because I don't have the file.
What type of prayer is this? Yes, madam. What type of
Your
prayer is this? You
Your
are
Lordship,
asking
I'm on behalf
the
of
state
Mr. Deep
respondents to take out the money from 8 kios. You can believe it. One again. What type of prayer is this?
Your Lordship, I'm on behalf of Mr. D. Chakravorty.
On behalf of
Mr. D. Chakravorty.
D. Chakravarti. What can I help you then?
He's left on another court.
Everybody is in leg. This the Mr. A.
Hey, Fukani, Lordship,
Kukan appearing on behalf of the
1, 2,
and who appears for the private respondent? You.
State Bank of India.
Huh?
State Bank of India.
Who is appearing for the private respondent? Taking into account of the private respondents are not represented it is still again on 27 2000.
Okay, then.
13 and 14.
Yes, what is this?
Lordship, matter relates to deduction of forest royalty in the context of field, Lordship.
This is same like Muslim Ali.
Lordship, it appears. Covered by this judgment passed by Lordship, Lordship. The same agreement, Lordship, same clause.
Yeah. Both the repetitions are taken up together for disposal, taking into account the similarity of the issues involved and the fact that the matter have already been dealt with by this court in another repetition. Have already been dealt with by this court by a judgment and order dated 24/11/2023 in WPC number 5305/2022. Bracket Muslim Ali versus State of Assam and others. The petitioner who is the same in both the petitions are aggrieved by the deduction of an amount of rupees 5,60,521 towards and rupees 10,29,387 towards forest royalty by the PWD department. And therefore have sought for a direction upon the PWD department for refund of the said amount along with interest. The said issue which have been involved which are involved in both the petition have been dealt with by this court in the case of Muslim Ali Supra.
Just one small permission I'd like to make, Lordship. In the present case, Lordship, one clause is there, 41.1, that permits such deduction. That is one, Lordship. And secondly, Lordship, when Park Philosophy failed to submit any document relating to payment of royalty in respect of sand and stone use.
In respect to
stone and sand used for the purpose.
There is no such clause in the agreement.
when there is no clause, how can you insist?
One clause is there, Lordship, 41.1.
Where is it?
Lordship, I kindly will file that in the order dated 16/10/2015.
No. 41.1,
Lordship.
yes, the rate quoted by the various shall be deemed to. No, this very thing happened, the royalty test and so is going to be taken. So I will perform such duties in regard to the deduction. Now, this very clause, this court has duly taken note of 41. 41 point, yeah. It is
One.
settled that shifting of liability is permitted by mutual agreement. However, it cannot be justified that the incidence of payment of goods only arise with a mining lease is fixed. Therefore, it is the opinion of the court that clause 41 of the act cannot be invoked to include royalty unless and until the mining lease or art granted to the contractor or the contractor contract forbids obtaining minor minerals from any other source other than the mine. So that 41.1 was duly taken care of. Illegally have already been dealt with by this court in the case of Muslim Ali Supra. Paragraph 15. To 21 of the same judgment is reproduced hereunder. Next, taking into account the above settled position of law as held in Muslim Ali Supra, this court directs the respondent PWD authority to release the amount of rupees, the amount of 5,60,000 in cash to the petitioner, which have been deducted from the bills of the petitioner on account of forest royalty within a period of how much? 6 months. Months is too late. Because earlier I have given 15 days. 3 months. 3 months from the date of a certified copy of the instant order is served upon the
Respond what chief engineer.
upon the chief engineer. It's the same chief engineer, both
In
chief engineer work.
PWD roads and PMGY work.
That is the respondent number 3 in both the reports. With the above observations and directions, the petitioner.
Hello.